Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name remains Aaron Asiedu Entry. In our previous edition on juvenile justice, we had lawyer Clement Upoku Jemfi to help us understand the juvenile justice. Lawyer, welcome.
Thank you.
So this is part 2 of what we started. We started looking at the preliminary stages entering into the court and ended on taking plea. Before I proceed, please like, share, subscribe, and tell a friend to tell another friend that lawyer Kwame Poku CID and kwada lawyer no de odwen and kwada hono wabetna se a yenene eba bedi nkomo. And I also implore that and tell you that this video is proudly sponsored by Nkrumah. They do all assorted kinds of foods. Their flyer is on the screen. You can contact them for any kind of food. Accra is very tiring environment. Make sure that you don't add cooking to your schedule to get you delay or meet certain deadlines. Employ the services of Nkrumah, and they would be able to deliver as of the time and the exact way you want it. That I trust them because they are those I subscribe to their services. Today we are looking at the trial itself, the trial of juveniles, and we still have lawyer Kwame Poku CID to help us. Lawyer, at the last stage, you mentioned that there are 2 types of bails, and I like it so much. First, the police inquiry. In fact, there are 3 types, but we looked at 2: the police inquiry bail and the bail pending trial. And you mentioned to us that ordinarily the police must grant the juvenile the bail, but in certain circumstances, when the offense is serious, they wouldn't grant the bail. And also the court too, where the circumstances are grievous, they wouldn't grant the bail, and they must state the reason. You mentioned that. Yeah. The point is, if they don't grant the bail, the juvenile is going on remand. For how long can the juvenile be kept on remand? And with regards to the remand, is the juvenile going to be taken to the maximum prisons or the normal prisons we have? You made us understand that even with regards to police cells, we should have a juvenile cell, which you've done well at Manso Edubia, right? Manson Crime, right? So with remand, are we taking the person to the remand cells, the normal cells every adult goes, or there is a special one for the juveniles? And for how long can that be kept?
Yeah, thank you. So this is like 2 or 3 in one question.
Yes.
Once the matter is brought before the court, now the court takes control, takes over the juvenile. Mm-hmm. So the position of the law is that if the courts refuse to grant the bail, mm-hmm, the court has the power to remand the juvenile. And in remanding the juvenile, the courts, mm-hmm, can do one of 2 things. Okay. Either to remand the juvenile at a remand home.
So there should be a remand home?
There should be a remand home.
I doubt there is one in Ghana.
Well, I'm yet to see it. There should be a remand home, which should be established by the Minister for the Social Welfare or Minister for the Interior.
That is in charge of internal
security. That is the position of the law. And or the courts can give the juvenile to the parents. Mm-hmm. That is what happens in most cases. Mm-hmm. The courts will refuse the bail, but will give or remand the juvenile to the parents, or the guardian, mm-hmm, or any responsible person within the community who is fit and proper person, mm-hmm, and is willing to take the juvenile for 7 days.
For 7 days?
Yes.
So the duration is 7 days?
7 days.
You can't go beyond 7 days?
You can go.
You can go beyond?
Yeah, you can go beyond 7 days, but the first one should be 7 days.
And the second
then,
one?
If you want to renew the remand certificate, sort of, mm-hmm, it's the juvenile must be present. Mm-hmm. And it is so because the juvenile was given to the parent or guardian. Mm-hmm. So you have to bring him or her back to the courts. Mm-hmm. That is where habeas corpus will come in. You produce the body.
Produce the body.
Exactly. For the court to see, mm-hmm, for the judge to see. And if in the course of the trial, the judge feels that you should still go back to remand, then it will be renewed. But it should not go beyond 3 months.
Okay.
Yes, so 1 week, like 7 days, then maybe another 7 days. Like, so a total,
the total remand
should not go beyond 3 months. And in a serious offense like murder, should not go beyond 6 months.
Okay.
For remand.
In a serious offense like murder, shouldn't go beyond 6 months. I want to ask this. You see, when you go to the court, when you're a lawyer or you're an intern at the court, one thing the court does is that when there is a criminal or there is an offender, an accused, and the court is even convicting the accused, after the court has entered into the conviction, mostly the judge gives the prosecutor an opportunity to ask that is he new or is he a first-time offender?
Yeah.
That influences the judge in passing the sentences and others.
Yeah.
My point is, does the court commission, let's say the probation officer, the social welfare officer, to do certain background checks, or does the court does any background checks to know whether that is the attitude of the offender, or there are certain circumstances surrounding it that should influence the judge in passing the sentence?
Yeah, even like you said, in normal practice, the judge, even before sentencing, would, apart from the prosecution making their case and stating in that you are a first offender or you're not a first offender, I mean, this is your third or fourth time here, the judge will even give you, the accused, the opportunity to say your last words before sentencing. So there are times that whatever you say, it's likely to influence the judge's sentencing. So sometimes a person may plead and say, "Oh, I didn't do that deliberately. It was an oversight." But those things do happen, and the judge can just say, though the judge will not say that because of that I've reduced the sentence, but in practice we know that it influences the judge's sentencing procedure. So in juvenile justice, it is similar. However, in this instance, there should be a social inquiry report.
Okay.
Social inquiry report on the young offender.
Okay.
Social inquiry report on the young offender. So what this social inquiry report seek to do is to look at the background of the young offender, the kind of home he's coming from, the kind of church, the kind of school he attended, and the kind of friends, associates he or she has that may have influenced the decision the young offender did. And so once that social inquiry report, it's done. It will be done by the probation officer.
Okay.
I know I explained who a probation officer is. The social welfare officer. Yes, so the probation officer will do the social inquiry report, and then later on present the findings to the court. The judge is not obliged to adapt the social inquiry report. It's not obliged. But if the judge is adapting the social inquiry report to use or for it to affect his or her ruling, there's no issue with that. But once the judge is rejecting the social inquiry report, the judge will have to give reasons to why he or she is rejecting the social inquiry report.
Okay, I get it. Now, the point here, my next question is that the young offender has been convicted. What are some of the sentences the young offender is likely to face? Would there be only fines because he's young and so he pays some money and go away? Or can he be incarcerated, as in put in behind bars?
Yeah, so a juvenile court which convicts a juvenile offender may discharge the juvenile unconditionally or conditionally.
So with a conviction, or let's say when the court is sentencing, they can actually leave him?
Yeah, they can leave you. Or they can just say, oh, go
away.
Unconditionally.
Okay.
Or conditionally, oh, okay, so go and sin no more. registrar ensure that he signs a bond of good behavior.
Okay. That is the condition attached.
Exactly.
Okay.
Yes. Or discharge your juvenile after he has given an undertaking.
Okay.
Like I said, the bond of good behavior.
Undertake that you will not do.
And then release the offender on probation.
What does that mean?
You give, so mostly it's done by the probation officer. So you give the offender back to the society.
Okay.
Or the community. Probation, just as when you are employed, then they say you are on probation. They will look at your attitude towards work for a while before you be confirmed.
Okay.
So when a juvenile is put on probation, they will look at your attitude after the offense
and check for
a period of time. If you have indeed changed, if you've turned a new leaf, you are a new person, you are a born again.
Okay.
If that is even the right word to use. So if you are born again, then the court could say,
well,
go.
But within that period, if you commit a crime,
then you've even worsened it. Within that period, if you commit an offense, then you'll be sentenced.
Okay, I get it.
Yeah.
So the probation, given and not taken, leaving either conditionally or unconditionally.
So then the offender could be put to the care of a relative, which I have stated earlier in the submissions, or any other fit person who is willing to take you, or send the offender to a correction center, order the offender.
The correction center is their prison.
Their prison.
Okay.
So you cannot say you've been sentenced to say 1 year imprisonment. No. But
you sentence the person to a correctional center.
Yes, to a correctional center. Because I not say you have been imprisoned.
I have a friend called Amasma also. She works at a correctional center.
Okay.
Yeah.
So, and then they can order the offender to pay a fine, damages or costs.
But who pays for it? A juvenile, he doesn't work.
So probably the parents will have to pay.
Okay.
And that is where the vicarious liability of crime. So you come in there, you come there.
Okay.
But you come there. I don't know if it is even proper. So you come in there, you come there. Or order the parent or guardian or close relative of the juvenile to pay a fine, damages or cost. Or order the parent or guardian or close relative of the juvenile to give security for the good behavior of the juvenile. That means you are standing in. This is my child, my son, my daughter, Papa lawyer, Papa judge, Mr. William the judge will say, "Me de na shawonsa."
Okay.
Mame, Papa, me de akwara no ashawonsa. She se akwara no ensa nkonko yesa boni bio. So now it becomes a charge on you to keep, to ensure that whatever offense the young offender committed, he will never go there again.
Okay.
Yeah. Or deal with the case in other lawful manner the court considers just.
Okay. So if you mentioned, so there are other options the court will consider just. You mentioned that the person can be sentenced to a correctional center.
Yeah.
Meaning technically a prison, but we don't want to use the word prison. My point is, for how many years can you keep any juvenile of any offense he commits? For how many years can you sentence a person? Because in ordinary practice with regards to criminal justice, we have death sentence, we have first degree felony, second degree felony, amongst others. So my point is, how many years can you keep a young offender, or can you sentence a young offender?
Can you correct a young offender?
Let me put that way.
So the law is that you cannot sentence a young offender to a correction center for more than 2 years.
Even when he's killed someone?
You can't do that for more than 2 years.
Even when he's killed someone?
You can't do that for more than 2 years. The more reason why Attorney General's Department always fights against the age of young offenders. They always contest it.
If the age is contested, why don't they do amendment in the juvenile?
Yeah, see, there is a court of appeal decision. I'll get it for you.
Okay.
Which, through the decision, in a way, has amended the act.
Okay.
But there are two decisions. One stands for the 2 years maximum. The other is deviating, is departing from the 2 years.
Okay.
So it depends on the beliefs of the judge.
Okay.
So if the judge wants to stick to the 2 years, there's a court of appeal decision to support. If the judge wants to depart from the 2 years, there's a decision to also support. So we are waiting for the Supreme Court to make a definite pronouncement on it.
But why don't you take it to the Supreme Court so that we have Opoku Jemfi number 1? Because if you wait for me to become a lawyer one day, I'll go.
Okay, that's fine. It's something that we've thought of it. Myself and Same thought about it, and we look at it because there are two conflicting decisions.
Okay.
Yeah.
Very well. Well, a question I want to understand. You made me understand that the Minister of Interior has the power to establish correctional centers, amongst others. You mentioned one thing I like, so I heard and I was quite surprised: vicarious liability. My understanding of vicarious liability is a master answering for the sins of a servant. With criminal law, you see, today, you've gone to commit your crime, and you want somebody to answer for that crime. Is that the case in juvenile? Is there a possibility of an adult party being punished for the criminal actions of a juvenile?
So as a student of the law, I know that you are very much familiar with this Latin phrase, loco parentis.
Yes, in loco parentis.
Yes, in loco parentis. So once you have that
onerous responsibility to take care,
fiduciary responsibility, fiduciary relationship, to ensure that you have to take care of the child. Your inefficiencies will put you into trouble, if it is even right to say that. Your inability or your inactions, because this time your actions or inactions,
yes, either act or
omission, could put you into trouble if you're a parent.
But the point is, I didn't tell him to go and commit the criminal offense.
The principle of in loco parentis is applicable here.
Okay.
And the position of the law. So here it's section 28, parent to give security. And it comes out to 28.4.
That is subsection 4.
Subsection 4. Any sums imposed and ordered to be paid by a parent, guardian, or close relative under this section, or B, on forfeiture of security given by the person may be recovered by distress or imprisonment. Then it goes further to say, as if the order was made on the conviction of the parent.
So in certain circumstances, you can imprison the parent.
Exactly. So my readings and my understanding is that even though the general principle is that crime has no vicarious liability, I think that in this exceptional case, in juvenile trial, in juvenile justice system,
in some circumstances,
crime has a vicarious liability.
I think we need to write a paper on that.
I've started something on that though. But so yeah, that is my understanding. You see, and I at a point I disagreed, but until this principle came to mind, that to every rule there is an exception.
Okay.
But the only rule that didn't have an exception when we were at the law school, law faculty, that we didn't know was the juvenile justice in crime. So we were taught that crime has no vicarious liability until I decided to do a bit of juvenile justice in my readings. I got to know that at a point, crime has vicarious liability. But that is under juvenile justice.
Oh. Okay. Thank you very much, Bra Kwame. I believe, are there any other things you would want to add up so that we wrap up in this particular sequence?
So I want to touch on the responsibilities or duties imposed on the Interior Minister and Minister for Social Welfare, if there is. Because at the time this act was enacted, we had Minister for Social Welfare and whatever. Especially the Minister of Interior. The Minister of Interior is clothed with so much powers that if he or she decides to exercise those powers, Ghana would be a better place to live. Because you should establish senior correction centers or junior correction centers. The Minister of Interior can so moto say that though the person is a young offender, he's committed an offense, leave him, let him go.
Okay, he has that power.
He has that power.
He has a prerogative power.
He has that power. I think section... a minute. I wrote it here. Section... The Minister of Interior, yes. Yeah, power of minister to discharge. So section 53, just
okay.
Section 53 of the Act.
Section
so
53
yes,
of the Act.
53, the minister responsible for social welfare or interior may at any time and for a reason considered appropriate direct that a juvenile or young offender be discharged from a center on the conditions that the minister considers appropriate,
so
which will also be in the best interest of the juvenile or the young offender.
So this one, the determination is even within the remit of the minister himself.
Yes,
he determines whether it is appropriate or not.
Exactly.
Then is that powerful?
So the minister in charge of interior is so powerful that if he wants to exercise those powers, I'm sure Ghana would be a better place to live.
Wow.
Yes, and there's one last thing I want to put across. So harboring or concealing a young offender, section 54.
Okay.
Section 54 says that a person who harbors or conceals a juvenile or young offender who has been ordered to be sent to a center or a remand home to be detained is liable on summary conviction to a fine not exceeding 100 penalty units or to a term of imprisonment not exceeding 3 months or to both the fine and the imprisonment.
So meaning when a young offender has been sentenced or to a correctional center and you tend to harbor him to prevent him from going to...
We use this word, keep.
You keep him.
Keep him or her. You've committed an offense.
Okay.
And you are liable to a summary conviction of 100 penalty units.
Okay.
So 100 penalty units, 100 by 12.
Okay.
Or to an imprisonment not more than 3 months, or to both.
Okay.
It depends on the judge.
I get it.
So to whoever is watching us, if you have any young offender who is under your care, under your protection, do not keep that young offender. Don't conceal or harbor him or her. Ensure that you take that young offender to the police or to the correction home.
Thank you very much, Kwame. We are grateful.
Pleasure.
And we are hopeful that other situations or circumstances you make yourself available to have a conversation with us here at the Law Lab. Here we say we dissect and unpack everything legal, and we pick topics that are critical to the society that people are not looking at. We are also doing community outreach. We pick a lawyer. The other time we were with lawyer Kingsley Saponaku, lawyer Efia Dramana has expressed interest at Easter. She's with us. I have a couple of lawyers, Gonzaga, Clement, and others. I believe you know them. They are all ready to join me to my beloved constituency of Bremen, neighboring towns, to enter into the villages and make them aware about all these legal processes. I believe that you make yourself available one of these days to join us in our advocacy in the hinterlands for them to get to know what the law actually speaks about. So thank you very much, viewers. This has been the dissecting juvenile justice, and I believe that you've been enlightened. If you are indeed enlightened, kindly like, subscribe, comment, and share, and get to know that this is the Law Lab. Tell a friend to tell a friend that lawyer Kwame Poku CID has dealt with juvenile justice. Don't forget that this video was sponsored by Nkrumah, and Nkrumah does all assorted food. Thank you very much, and see you on our next episode.